Well, now turning to property rights, what are property rights? Property rights, in a way, are the things you get from your tenure. So if you think about tenure as the overarching institutional arrangement for the way you engage with land and resources, property are the rights and the obligations, or the rights and responsibilities that you hold based on your tenure with regard to a particular thing. So lawyers and economists will often talk about a bundle of property rights. And sometimes when you say, for example, have a freehold right to land, you'll have a really thick bundle of property rights. Remember though, when we were talking about renting a car earlier, if you rent a car, you have a thinner bundle of rights in relationship to that car. So let's talk about that bundle for a minute. The bundle for lawyers is composed of a series of sticks. So bear with me for a second while I explain this. If I own a piece of property, I have a pretty thick bundle of rights. I might have rights to use water on that property if there's any water. I might have rights to graze my animals. I might have rights to gather any wood that's on my land. But notice that with each one of these examples, I could also trade my stick to somebody else. If I'm in a customary system, I, as the chief or the head man or the traditional authority in that area, I may have some rights to manage many of these sticks in the bundle, and I'm going to give them to different people in my community to allow them to use the water or gather the firewood or graze their animals. Having the ability to distribute these sticks is a kind of power. It also provides an entrepreneurial opportunity. So in the developed world, you'll see people who hold thick bundles of property rights, thick bundle of sticks, oftentimes trading out parts of the stick. So I might sublease my land to somebody, that's a stick in a bundle. Or I might allow someone to create an easement, an ability to move over my property to get somewhere else. That's a stick in a bundle. So again, it's not necessarily the case that everyone needs to have thick bundles with many sticks, but you want people to have enough sticks to create the incentives to invest in land, protect it, and conserve it. Economists will sometimes talk about the bundle of rights a little bit differently from lawyers. Economists, especially Nobel laureate Elinor Ostrom, talks about the 5 kinds of categories that you see here as being important to create robust property rights. So do you have access rights to land? Can you take things off the land? Do you have the right to manage the land? Can you keep other people out? This is a really important right, exclusion. And can you sell? So having all those rights together gives you a pretty firm, secure right as long as they're enforced. Having fewer of those rights may make you a little bit more vulnerable. I mentioned earlier that one problem that can drive insecurity is the problem of overlapping legal systems. And this graphic here will show you that in a lot of environments there actually are a number of legal systems related to property that overlap. So you can have international rules around property, as with CEDAW and women's rights to land. Those international rules exist in a nation state where there will be another set of formal rules and statutes related to land. And in some countries, religious principles or laws also play a role in allocating land and other property. But you might be doing a project in an area where the formal rules don't apply and it's a customary system that actually is most applicable to people on the ground. So you've got a customary system that exists or is nested within a state system that's formalized, that is also nested within and fits within an international system. And this kind of legal pluralism can create insecurity, it can create some confusion around who has rights to what. So let's talk very briefly about the concerns related to legal pluralism. A lot of times these different systems in the developing world are not well coordinated. The formal system doesn't speak to the customary system. Formal lawyers in the formal sector don't understand how disputes are resolved in the customary system. Bridging that gap between the customary system and the formal system is seen as an increasingly important job for development practitioners, understanding what are the rules and principles in the customary system and how can those rules and principles be used to strengthen the formal system is a real challenge for us and sort of the frontier of land programming at the moment. If you live in a system where there's high levels of legal pluralism, you might face some other concerns. So it could be that in this legally pluralistic environment, the pluralism itself might create insecurity for you. It might also mean, though, that you don't really pay attention to the formal system. You exist in this customary system, and you're actually relatively comfortable and happy there because this formal system never does talk to you. So I just want to emphasize again that the key challenge for development practitioners is getting people to a secure enough place. And you may be secure enough, even in a legally pluralistic environment, if where you are living today and where you're going to be living for the time being and the resources you're going to be using are going to be respected and protected by the people who are governing this area. And you're not going to be infringed upon by people coming in from outside.